Dr. Ochab, can I take you, first of all, to 1941 and a radio broadcast by Winston Churchill, who said that there was no word sufficient to describe the monstrous crimes which had occurred in the Holocaust. And it took a Jewish Polish lawyer, Raphael Lemkin, who'd lost over 40 of his own family in the Holocaust, to give us that word, genocide, the cutting of the human family. And great hopes were held out that the Convention on the Crime of Genocide, the 75th anniversary of which we're marking this year, would somehow stop what Pari Ibrahim said earlier on in her excellent contribution, would stop it happening all over again. And yet from Rwanda to Bosnia and many other places, we've seen it happening again and again. Can you remind the Joint Committee that apart from the words like predict, prevent, punish, apart from those words, what are the actual detailed obligations under international law that fall on the United Kingdom to try and prevent these atrocities from occurring?
Thank you very much. So, of course, we are talking about the Genocide Convention, which not only defines the crime of genocide in Article 2, but also imposes obligations upon states to prevent and punish the crime of genocide. And starting with the duty to prevent genocide. The convention itself does not explain what it means, how this duty is to be implemented, but there is a very important judgment from the International Court of Justice from 2007 that talks about what actually prevention means. And paraphrasing, we don't have to wait until we see bodies on the streets, because then we are not talking about prevention. We have to act much, much earlier. And the Joint Committee, the International Court of Justice confirmed that the duty to prevent arises at the instant a state learns or should normally have learned of a serious risk of genocide. And that is the trigger point for the duty to prevent genocide. And unfortunately, that's one of the duties that is not implemented pretty much anywhere in the world. Because in order to implement this duty, states should have domestic mechanisms that will enable them to identify early warning signs and risk factors, to identify situations at serious risk of genocide in order then, of course, to trigger the duty to prevent genocide. And, for example, in the UK, there is no such mechanism. This was recommended recently in the Bishop of Truro Review to ensure that there is a mechanism for early monitoring, early warning signs of atrocities to come. In response, the government established a small team of, I believe, 3 individuals who are monitoring the situation, but unfortunately, we don't see any result of this work at this stage. And then, of course, the government has this joint JAX assessment, which is joint assessment on conflict and stability. But unfortunately, this assessment is not available to anyone. It's only for government's eyes. So even this place, the parliament, cannot check whether the government is actually following its own advice identified in this assessment, which is very, very concerning. And at least parliamentarians should have access to it, to know, again, whether the government is doing what it's actually identified for itself to respond to atrocities. And then, for example, in the US, there is definitely much more work being done in relation to monitoring early warning signs, especially with Elie Wiesel Act. That was adopted some years ago, and there is annual review of situations at risk, situations of concern, and also identification of the steps taken by the US government in response to those situations, which provides more clarity, provides more transparency as well. It's not perfect, but nonetheless, this is a great start in order to implement the duty to prevent genocide. And then very briefly on the duty to punish genocide, the second duty incorporated in Article 1 of the Genocide Convention. The duty to punish genocide, of course, requires us to introduce laws that will enable us to prosecute the perpetrators, but also requires us to actually prosecute them, be involved in the prosecutions, and help international tribunals as well to prosecute others. In relation to this duty, of course, in the UK, there is law on genocide. Initially, it was the Genocide Act from 1969. It is now repealed. There is a different law. It's the International Criminal Court Act from 2001. And this law replicates, of course, the wording of the genocide of genocide from the Genocide Convention, which is then replicated in the Rome Statute. And but if we look at the provision, the scope is much narrower in terms of course, it provides for universal jurisdiction, but only in a very limited number of cases. It is more extraterritorial jurisdiction rather than a universal jurisdiction. But I believe we'll be discussing it later.
So if I may, Chair, your recommendation is that the JAX reports that are drawn up for situations such as that in Tigray at the present time, which we know exists, that should be available to members of Parliament at the very minimum, that there should be more transparency. Can I ask you about other gaps in the Genocide Convention? One of them, for instance, around the political classes who are not covered in a country like North Korea, which comes out in the 10th anniversary of the United Nations' own report by Mr. Justice Kirby into atrocities in North Korea, that they are simply not covered as a group. Or during the Daesh atrocities, the killing of homosexuals, the throwing of gay people off buildings, that they are not covered as a group of people, as an ethnic group or a racial group. Is that another gap that perhaps needs to be addressed? And finally, the French have put forward proposals for the reform of the United Nations Security Council, but at least in the case of atrocity crimes, that the veto should not be available to those members of the Security Council. And clearly, with countries like China and Russia sitting on the Security Council, they prevent referrals to the International Criminal Court. So is that something the United Kingdom should be attending to, and is it something we should be supporting?
Thank you very much. I definitely would support the disclosure of JAX, at least to parliamentarians, to make sure that they can review the government's responses. If it's not to all parliamentarians, at least to relevant. So in relation to JAX, I believe that there is a greater need also for some kind of a trigger point when this signs, risk factors were there long time before the war began. The JAX assessment was done first in 2022, I believe, 2 years into the war, not as the war started, not before that. The FCDO waited, or the government waited 2 years to do the assessment of the risks, which doesn't make sense. It just does not make sense. So I think there should be a trigger point in order, for example, if, let's say, the Joint Committee on Human Rights is concerned, or the Foreign Affairs Committee is concerned about this situation, write to the Secretary of State to conduct the JAX assessment, and this should be done within the next, 3 to 4 months, or even earlier, subject to availability, of course. But if there is nothing of this sort, it's a matter of coincidence whether the JAX assessment will be done or not. And again, if this is a mechanism that the UK government is using to identify early warning signs of risk and risk of atrocity crimes, we need to engage with it in a different way, and this is not being done at this stage. So definitely there is a need for a change. In relation to other questions, Genocide Convention and its limitations, of course, Lemkin wanted a very different definition, much broader definition of genocide. But unfortunately, of course, once the drafters came together, and because of the different interests of states at the time, unfortunately, political groups were excluded from the definition. Whether it should be amended, I think that would require a lot of time, a lot of attention, but nonetheless, considering the political targeting of individuals, and North Korea is a great example, this is definitely something to look into. French proposal on the veto, yes, and there is quite some support for this proposal. Of course, it would be only resigning from the veto right in relation to atrocity crimes rather than across board, but nonetheless, this is the way forward. And I do have a counter-proposal as well. If, of course, states are not willing to freeze their veto in cases of atrocity crimes, to have also a procedure, a follow-up procedure, that if something was blocked at the UN Security Council, by default, take it before General Assembly. In many cases, you can't do the same. You cannot establish ad hoc tribunals. The options before the General Assembly are limited, but at the same time, you can do certain things. And a good example is the response to the war in Syria. When the resolution referring the situation in Syria to the ICC was blocked by China and Russia, states came together and tabled a resolution before the UN General Assembly, establishing a mechanism to collect and preserve the evidence of the atrocities. And of course, Syria didn't like it, Russia didn't like it, but nonetheless, there were enough, a good number of countries that supported it. The resolution received a majority, and that is what is required at the General Assembly, and the mechanism was established. And now the mechanism continues to collect, preserve the evidence without even going to Syria, and they've been working with prosecutors in 12 different countries to help with prosecutions of the perpetrators. So this is a good example how the default position that if something at the Security Council doesn't work, let's take it before General Assembly, there is no veto right there. We need majority to proceed with certain steps. We need to be flexible with such situations if one body is frozen because of interests of certain countries.
Thank you very much indeed. Thank you, Chair.
Thank you.
I want to pick up on your point, actually, about the naming of genocide and then the ability to prosecute on that basis, because in 2014, after these horrific events that Parry described to us in Sinjar, the then Foreign Secretary, Boris Johnson, said it can only be described as a genocide, quote unquote. That was on the public record. The House of Commons, in a vote, decided in 2015 it was a genocide. Right. The House of Lords, by 3-figure majorities, supported amendments to the law to enable the High Court of England and Wales and its equivalent in Scotland to be able to have before it a determination of whether a genocide is underway. The only reason why the Yazidis could now be prosecuted, people who have done these things to the Yazidis could be prosecuted for genocide in the UK is because we have accepted the decision of a German court, thanks to Amal Clooney and others,
right,
that this was a genocide. But this is isn't this a bizarre situation, a totally contradictory one? What would be your recommendation to the Joint Committee and to the government on this?
Before I answer the question, I wanted to just re-emphasize what the Chair said about those returning. So in relation to the Daesh fighters who return, British citizens, we have clear jurisdiction to actually prosecute them for genocide, and this has not been done. And then, of course, there is a question of the Attorney General concern. But in those 425 cases or 360, I think, again, needs to be double-checked with the government, there is a clear jurisdiction, universal jurisdiction to proceed with those cases.
Good.
And the question is why this has not been done.
Been investigated.
So just to rephrase it, because that's a very important question. And then in relation to determination of genocide, the UK government's position is that it's not for politicians, it's for courts to make the determination of genocide. We don't know exactly where this is coming from. It's a long-standing policy, but it does not seem to have any proper source, and definitely not in law. And I remember when I was just starting working on the situation of the Yazidis back in 2015, we've been already hearing these arguments. At the time, we were hearing it also from the Canadian government and the Dutch government. In 2016, there was a very important report and research done by the Commission of Inquiry on Syria, and they published a report they came to destroy and recognize the atrocities as genocide. Following that report, the Canadian government recognized the atrocities because they said this UN report is enough for us to make the finding that this is genocide and treat it as such, provide assistance to the Yazidis and so on. In the Netherlands, the Dutch government actually requested a report from independent experts dealing with 2 questions: whether politicians can deal with the question of genocide, and the second, whether the Daesh atrocities amount to genocide. The expert came back with a response saying that yes, politicians can deal with the question of genocide and should, if there is enough evidence, of course. It should not be just taken out of nowhere. There has to be evidence in support. And in relation to the second question was whether the atrocities against the Yazidis amounted to genocide. And the response was yes, there is enough evidence to suggest that the atrocities amount to genocide. And despite the fact that those two countries started as the UK, that is not for politicians, it's for international courts or courts to deal with the question. The UK government did not change its position and continues with the argument, leave it to courts. And as this argument was being said, I remember seeing a lot of messages, both from Baroness Kennedy and Lord Alton, challenging the government's position because, for example, initially it was meant to be for international courts. That was the line from the government, that we need international court deciding it. But at the time, there was no international court to even engage with the question of Daesh atrocities. ICC didn't have the jurisdiction. ICJ could not be engaged. There was no ad hoc tribunal to deal with the question of genocide, despite efforts from a number of countries. So in response, the government came back with a slightly adjusted version of saying it is a matter of competent courts. So it could be a domestic court, for example, a criminal court. At the time, there was already one decision from a German court that the atrocities are genocide. But unfortunately, that decision was being appealed. So the government's response was that, it is being appealed, we are monitoring once we have the final decision, then we'll decide. In the meantime, there was a second decision from a German criminal court, was not being appealed. Then, at the beginning of this year, a higher court, appeal court, confirmed the first recognition of the atrocities as genocide. So at the time, there were two determinations. The UK government did not follow on that. A few months ago, there was a third determination of the atrocities as genocide. And again, zero response from the government until August this year. 9 years after the atrocities, in the meantime, there were 3 court determinations from German courts, which have done incredible work using universal jurisdiction. And just going back to Germany, in Germany we have now 3 determinations of genocide and 5 of crimes against humanity. Just as a comparison.